Good afternoon, everybody. Today is Thursday, March the 16th, 2023. My name is Angie Vosing, and I am the president-elect for PACO. Today, we welcome Doug Koppel. He is an attorney with the firm of A.G. Clymer. Doug has been representing workers' compensation claimants since 2010. He spends most of his time in A.G. Clymer's Columbus office, but also is the coordinator of the Circleville office. Doug is a lifelong resident of Central Ohio and attended The Ohio State University for both his undergraduate degree and for law school. Outside of work, Doug enjoys following OSU sports, reading historical nonfiction, playing historical war games with his son Grant, playing hide and seek with his daughters Noelle, and traveling with his wife Kelly. Welcome, Doug.
Thank you.
I do want to, before we begin, thank Megan Rogers and Spectrum Reporting for providing today's Zoom link and recording today's session. As most of you probably already know, we will post a recording of today's session on our website under the Members Only tab in a few weeks, so that if you want to go back and review something, or if you had to hop off early, you can catch the last part of it. Just real quickly, a couple of announcements. First of all, Paralegal Day is coming up. It is 2 months away. I believe the date is May the 13th. It's on a Monday. Ticket sales are now live on our website, so you can certainly go check that out. And also our sponsorship information is live on the website. So if you know a vendor or if your law firm wants to be a sponsor, all the information can be had there on the website. Paralegal Day is Monday, May the 15th. Thank you, Becky. I apologize for getting that date wrong. I wasn't sure about the 13th, but I went ahead and said it anyway, and I shouldn't have. I don't know of any other announcements. Does anybody that's here know of anything? Okay, then I will turn this over to Doug. Welcome.
Thank you. Thank you for having me. I'm going to be speaking on COVID claims and how they're dealt with in the BWC system. And Angie told me that any questions typically will be sent through chat rather than vocally. That's fine either way. If you have any questions, feel free to ask. And of course, at the end, I do think we'll probably have some time at the end if anybody has questions then. So let's get started here. So the first thing I want to do is take everybody back to January 20th of 2020. And couple things to put you back in that moment to remind you what was going on back then. So Donald Trump was unveiling his defense for his first impeachment. The Chiefs and the 49ers had just advanced to the Super Bowl. Bad Boys for Life was the top of the weekend box office. And Parasite became the first foreign film to win a SAG award. So a little while ago, these things happened. And it's funny because it doesn't seem that long ago. But January 20th, 2020 is also the first case we had of COVID in the United States. And that was in Washington State. And it was followed by what I remember to be 2 very tense months in Ohio until we had our first case our first cases in March. March 10th, we had 3 cases confirmed, I believe, in Cleveland. And that's when Governor DeWine declared the state of emergency. I actually remember being at a store on Valentine's Day, buying supplies for our office, trying to buy wipes, disinfectant wipes and things like that, and just the shelves being completely empty. So it was definitely an interesting time. So as a workers' comp representative, your first thought, whether you're claimant or defense, is, well, what's going to happen now? Because obviously this is something going to happen. People are getting sick, and some of them are going to allege that it's happening at work. So the BWC did put out a release on March 30th. Said the question is, if I contract COVID-19, is it compensable? And BWC basically says, if you look at the, typically it says diseases are not typically compensable, but at the bottom here it says, however, if you work in a job that poses a special hazard or risk, and you contract COVID-19 from the work exposure, BWC could allow your claim. And if you are familiar with the standard for occupational diseases in general, then you may recognize that language. Not, we will get into that soon, but the special hazard language applies to all occupational diseases. So then the question is, when you're trying to figure out how the BWC is going to deal with this back in 2020, you're thinking, well, has the BWC ever dealt with anything like this before? Just to give you the idea of the scope of COVID, really nothing in living memory is like COVID. The examples, you've got swine flu, SARS, Ebola. This is actually, I believe, deaths. So it's not necessarily cases or hospitalizations, but still a visual representation that this is not like anything we've seen in the new millennium. Just for an example, swine flu, I think the CDC estimate I have for the 1 year of main communicability or main infection with swine flu was 275,000 hospitalizations, and we're in the US, and right now in the US we're at 6 million for COVID, so much higher. In fact, in January of 2022, the highest single day of new COVID cases, January 10th, 2022, we had 1.35 million new COVID cases in the US. That means on that one day, 1 out of every 250 people in the US diagnosed with a new case COVID. So pretty extreme compared to what we've seen in the past. And really, you have to go back to the 1918 flu, which was H1N1, also the same as the swine flu. It was the H1N1 virus variant. They had 25 million cases back then. Population was about 100 million back then, so about a quarter of the population got it. And there is a case that a lot of people recently looked to, or near the beginning of the pandemic, looked to with some curiosity, because there was a case in California that dealt with the flu pandemic in 1918 and made it up to the Supreme Court of California. And that is City and County of San Francisco versus the Industrial Accident Commission. And that's a case where the claimant was a hospital steward, which I was not really familiar with that job title. Apparently it's somebody who kind of does odd jobs around the hospital. They kind of fill in with help with the nurses, help with the doctors, do all kinds of varying things around as they're needed. But essentially, a lot of the jobs that a nurse's aide or nurse would do, physician's assistant, maybe. But in the event, he contracted the flu during the pandemic and died. His widow filed death benefits and won. The employer, the city and county, appealed to court, and they made 2 arguments. And again, this is 100 years ago, so the law was not very developed with workers' comp. But the 2 arguments, the first argument was diseases can only be compensable if they are caused by a physical injury, because workers' comp is supposed to be for injuries. So if you cut yourself and get infected, that's a disease that workers' comp would cover because it's related to an injury. But a communicable disease that you just catch is not an injury, so it should not be allowed. But more importantly, and more relevant for now, is the second challenge they made, which is that there is no evidence that the disease was contracted in the course of and arising out of the employment. So again, that's really just saying causal, we're questioning the causal relationship. How are we to know that the disease was in any meaningful way caused by the employment? The employer argued that the flu was raging in San Francisco at that time. It was highly contagious. It was spread all over the place. 1 in 10 people in San Francisco had it. So essentially everyone in the public is being exposed to it all the time. Why is work responsible for taking care of his illness when it's a widespread community illness? And the court looked at his case in particular and said, well, this flu has an incubation period of 1 to 4 days. In the 5 days before his infection, he had been exposed to at least 12 flu cases at the hospital. He had no known exposures outside of work. He'd been working very long hours and had not been outside of his house or work as far as anybody knew. And they also noted that the exposure to people in hospitals had been much higher. And for instance, nurses in the San Francisco area had 50 to 85% of them had contracted the flu, depending on which hospital they worked in, versus 10% in the community. So that's a huge difference. That's 5 to 8.5 times as likely to get it. So they found that it was related to his work because he had this significantly higher exposure, and because there was a fairly high likelihood that he had actually in fact gotten it at work, because he could rule out these other possibilities of getting it at home or outside of home. So if we go back to 2020 and we look at it kind of under this lens, what ended up happening with all these people getting COVID and alleging it was from the work? So in the first approximately 3 months, we have about 650 COVID claims filed. 456 of them were state funded. About 38% were approved, 15% denied, 34% dismissed, and 13% were still pending at the time at the end of the 3 months, so they hadn't been decided yet. And 208 were filed with self-insured employers. Almost half were approved, a little over a quarter were denied, and about a quarter were still pending. We don't know how many were dismissed or withdrawn with self-insured employers, but it's a fairly good approval rate. So it's a fair amount of them were being approved for COVID. But the question then becomes, let's look, how were they being evaluated once they're filed? How do we know what it takes for a COVID claim to be approved? Because it's a little bit different than a typical workers' comp injury. The typical workers' comp injury, we're looking at, was it an injury in the course and scope of employment? Was it arising out of the employment? And if it is, then you've got a workers' comp claim. But with COVID, it's a disease. So we've got a little bit different set of rules for occupational diseases. And those come from Ohio Revised Code section 412368. And that section lists the specific compensable occupational diseases. There's a list of scheduled diseases that are occupational diseases. COVID is not one of them. But then there is the next section says also a disease that meets the definition of an occupational disease is compensable pursuant to this chapter, though it is not specifically listed in this section. So if it meets the definition of an occupational disease, then it's compensable, even if it's not on the list of occupational diseases. So obviously the next question is, what is the definition of an occupational disease? But before we get to that, I just want to point out an important side note. There is a difference in the statute of limitations between occupational injuries and occupational diseases. It's very important to remember. With injuries, we have Revised Code 412384, you have 1 year from date of injury. Diseases, you have 85, which is the latest of the following. 1 year after disability due to the disease began, and typically they've interpreted disability to mean missed work. 6 months after a doctor diagnoses it as an occupational disease, or 1 year after death resulting from the disease. So it's the latest of those. So you may have longer than 1 year to file. So now we can get back to that definition. So let's see what that is. The occupational disease definition comes from Revised Code 412301F. Occupational disease means a disease contracted in the course of employment, which by its causes and the characteristics of its manifestation or the condition of the employment results in a hazard which distinguishes the employment in character from employment generally, and the employment creates a risk of contracting the disease in greater degree and in a different manner from the public in general. So that's not very clear, obviously. That's a lot to take in. But basically, I underlined what I think are the important parts. You've got to get it at work, course of employment. Your work has to create a hazard that gives you a greater risk, essentially, of getting it than other forms of employment, and you have to have a risk that's greater from the public in general. And before we go into that, I want to at least show you where that comes from. Jump into the details there. It comes from the Ohio Bell versus Price case. It's a Supreme Court case from 1975. They use a little bit different language, but it's pretty much the same thing. It says it must be contracted in the course of employment. Disease must be peculiar to the claimant's employment, or the conditions of employment must result in a hazard greater than employment generally. And the employment has to create a risk of disease in greater degree in different manner than for the public. Okay, so the definition was obviously fairly long and convoluted, so we'll break it down into the three main parts. The first part being the course of employment. So it's not specifically defined for occupational diseases. I put a question mark there because I can't say that with certainty, but I could not find any cases specifically defining what the course of employment is for a disease, but we do have a lot of definitions for what in the course of employment means for an occupational injury. And from the cases that I saw dealing with occupational diseases, it seems like they're applying the same one as occupational injuries. So if you look, the main case on that, it has been for a long time, Fisher versus Mayfield, Supreme Court case, says they interpret in the course to associate with the time, place, and circumstances of the injury. So time is, did the injured worker contract the disease or injury during or in close proximity to their work hours? Place, did the worker contract the disease at the workplace, work site? Circumstances, was the worker doing something related to and or incidental to the employment? So these are all factors to consider. The court doesn't say, there's a black and white cutoff of what's enough of one or enough of the other and what isn't. But it seems like if you're clearly missing one, you're probably out of luck as a claimant. You probably have to at least arguably meet all of them. And I think it makes sense to look at time and place first, since they're fairly related. And in the context of occupational injuries, if you're looking at time and place, obviously, if something happens while you're at work, if you're lifting a box at work, at the work site during paid work hours, you're not really going to have a dispute over time and place. But where we see kind of the gray area would be something like the parking lot cases you see. So, for instance, did the injured worker clock out and then they slipped on the sidewalk outside the front door? Or were maybe they clocked out and then they were hanging around talking to people outside for half hour, smoking and just chatting, and then they walked into the parking lot and they fell walking to their car? Well, both of them, the place, they're somewhat close to the workplace, but the time, one of them clearly has a better time argument. I don't know for sure which way either of those would go, but one of them certainly has a closer time argument. And another example would be, somebody hit by a car when they are in the parking lot walking during a paid break to get something out of their car. Or compare that to somebody who has a paid break and they're going across the street to get coffee or something, and they're hit going across the street. Well, both of them are still on the clock. So, the time is probably okay there, but one of them has a much easier argument with place. So it's similar with contagious diseases. You have to show by the preponderance of the evidence that it was likely contracted in the course of employment. So at work, during work, ideally, or close to it. Same as with an occupational injury. That can be a little bit trickier because you can't typically pinpoint the moment or place that you contracted the disease. So I've got just an example on time. So time, just to pull that one out specifically, did the worker contract the disease during in close proximity to work hours? So again, most of the case law we have is occupational diseases, but they seem to follow the injury definition. And courts have consistently said it doesn't have to necessarily be during work hours, but the closer you are, the better. So, the example is the parking lot cases we just spoke about. I don't think this is going to matter as much with occupational diseases or COVID in specific, because it's kind of hard to think of gray area on timing on catching a disease, because you really can't pinpoint, did you get it while you were walking out the door, or 30 feet from the door, or a half hour after work. It's usually going to be fairly clear where your exposure was and when it was, if you're filing a claim. So here's a real life example. And again, this is kind of an obvious example, but like I said, I think they tend to be that way. This is an police officer who typically does desk work by himself, but he was teaching a class on DUI, and it included breathalyzer training. So he was in a class, I think it was 75 people or so, and he was within 18 inches from all these officers' faces, showing them how to do the breathalyzer test. And he contracted COVID, and his claim was denied. It said the claimant did not experience any physical symptoms until January 26, 2022. That was 26 days after he'd finished those classes. So the hearing officer found that was too lengthy of a time frame between his last possible exposure due to this increased hazard of teaching these classes. So the timing didn't line up. So it's kind of an obvious example. You can't show that he got it at work. You can't show that he got it close to work or right after it. He has no evidence that it lined up at all. So the timing is just not there. Then, of course, you got place. Did they contract the disease at the workplace or the work site? And again, it doesn't have to be strictly on work property. Again, the example that comes up first is the parking lot cases. It could be at the workplace, but it could also be at a work picnic, a work party, things like that. The courts have found that with injuries that events that benefit the employer can also be argued to be related enough to meet the requirement. So there's cases where people were injured at picnics or parties or things like that work had arranged, even outside of work hours, and that was close enough, as long as it was beneficial to the employer. And there's several other factors. But in any event, the important thing to remember is that applies, as far as we can tell, to occupational diseases as well. And this one might be a little bit more open to argument than time. And the example here is a detective who believed that he contracted COVID at work, but in the end didn't really have the evidence to show it. So it says you can't say positively with any positivity that he contracted COVID-19 at work, no specific event at work, indicative of exposure. He'd been exposed to groups of 10 or more people at the grocery store and restaurants outside of work. No knowledge of who had COVID-19 around him. His job as a forensic detective did take him to crime scenes, and he did interact with police officers. But again, the problem here is he's not able to show the place that he got it. It could be anywhere. So the next one, last one, is circumstances, with the worker doing something related to and or incidental to their employment. So again, it does not have to be strictly while you're doing a work duty. It's related or incidental to your employment. So if it's consistent with your job and in some logical way related to or incidental to your job. So here are some real examples from Ohio court cases. Somebody was hurt stepping down from a company provided tram that takes you from the parking lot to the building that's quite far away. That was found to be related, even though he wasn't performing a work duty at all. Someone else was injured after he started work, but was returning from a meal at a restaurant, which was a company custom. Apparently they liked to go to this restaurant as a company, and they did it frequently. And that was enough to make it incidental to his work because it was a work custom. Someone else was injured while at home picking up advertising materials that the employer wanted them to pick up. And lastly, there was somebody, in our case, who was hurt on the premises of the employer when they went back to collect their wages after they've been terminated. So, that's certainly not performing a work duty. And We have one interesting example that we did represent. This is a police officer who got COVID at a Christmas party. And he said he was scheduled during his shift. It was organized by his supervisor. He was on the clock. He was in uniform. He was on call. He would have had to use paid leave to take time off. And there were at least 7 known COVID cases arising from that Christmas party. So the circumstances there, even if you leave time and place out of it, the circumstances are he was not doing a work duty. I mean, he was on call, but he wasn't really doing a work duty. But it's pretty clear that is in some logical way, it is related to or incidental to his employment. And really the time and place are baked into it. I mean, the fact it's not irrelevant that he was on the clock, that he was at a place where his employer had set up this party. So time, place, and circumstances are listed separately, separated by commas, but they're really they're all kind of baked together. It's really a balancing act. So here's an example that incorporates them all. Injured worker is proved by a preponderance of the evidence. Oh, I should mention this is a steel worker who contracted a lung disease. So over his employment from 1992 to 2000, he was exposed for 8.5 years while working as a rollover operator, exposed to dust, silica sand, formaldehyde, and a binder chemical on a daily basis, caused him to contract this lung disease. So time, 8.5 years during work hours as a rollover operator, place at the steel mill, circumstances, clearly while he was doing his job, something consistent with and related to his job duties. So that's one where you see them all baked in there. So quick check-in. We have done the first one, contracted in the course of employment, time, place, and circumstances. I promise we are much more than a third done though. The last two go more quickly. Okay, so the second one, peculiar to employment or hazard greater than employment in general. So what does peculiar to employment mean? Because the definition, the dictionary definition of peculiar to employment sounds a lot like it would mean it's a disease that you only get from this type of employment. But that's not what it means. The Supreme Court said in the Christ case cited earlier, the phrase particular to the occupation is not here used in the sense that the disease must be one which originates exclusively from a particular kind of employment. It goes on to say, rather, in the sense that the conditions of that employment must result in a hazard which distinguishes it in character from the general run of occupations. So in other words, peculiar to employment means the same thing as a hazard greater than employment in general. It's just saying it must result in a hazard which distinguishes it from the general run of occupations. So when it says up here, prong to peculiar to employment or hazard greater than employment in general, the or doesn't really need to be there because they're the same thing. So what does hazard greater than employment in general mean? Kind of common sense there. It's not specifically defined, but it seems like it must be greater by a significant degree. You're not going to most likely get an occupational disease claim from a job that gives you a 5% higher chance of getting a disease. Some of the case law certainly gives you that impression. For instance, in the Christ case, again, they cite a Michigan case that says plaintiff's work presented a substantial hazard of back injury, which was far in excess of that attending employment in general. So, again, we're looking at cases where typically it's going to be something that's quite notable, notably different. And then, let me go back a second. And then another example would be firefighters. They have a 250% higher risk of certain types of cancer than the general working population. So that would be pretty significant. And they do get cancer claims fairly often. Or like the nurses from the California flu case, they were getting it at 5 to 8.5 times greater than the public. Some other examples, histoplasmosis, not a very common disease you hear about. It's caused by fungus from bird excrement. A lot of people who work in chicken coops, farmers, people who do excavations and dig where birds have been using the restroom can get that. So that's a disease that would be much higher in incidence in certain jobs. Heart and respiratory diseases from people who work around insulation fibers or silica dust, like the steel worker did, diesel fumes, things like that, much higher. Carpal tunnel syndrome, people who work with machine tools repeatedly on assembly lines, things like that. Another one is a funny one. I shouldn't say funny. Another unusual one is a dishwasher who got tuberculosis. He was working in a tuberculosis asylum. So, you know, dishwasher is not a job with a high incidence of tuberculosis, but if you're working at a tuberculosis asylum, then certainly you have a much higher risk getting tuberculosis than the populace in general, or the work or other run of jobs in general. Okay, so hazard of employment, here's an example. This is a hearing loss claim for a police firearms instructor who's been doing it for over a decade. Says he's sustained his burden of proof for the right-sided hearing loss. He had repeated exposures to loud sirens and firearm discharges. He also was a firearms instructor for approximately 12 years, repeatedly and continually exposed to noise from weapons discharges, often had to take his ear protection off to speak with other officers, even though other weapons were being fired on the range. So they found that this was a hazard of his employment, distinguished from employment generally, and there's a greater risk of developing hearing loss than that to which the general public is exposed. And that seems true. I mean, most jobs are not going to have you hear gunshots within close proximity to you for over a decade or anything anywhere near that loud. So that would be an example of a hazard. So we'll move on now to prong 3, which says employment creates a risk of disease in greater degree and different manner than for the public. So before I get into this one, I think it's worth asking, how does that differ from prong 2? So prong 2 was it's a hazard greater than employment in general. Now this is saying it's a risk of disease higher and in different manner than for the public. And for me, I can't think of an example where a job would have a higher chance of getting a disease than the public, but not a higher chance than the working public, you know, than jobs in general. And I can't think of the inverse either. I can't think of a job where you're more likely to get a disease than most other jobs, but not more than the public in general, not more than non-working people. So I don't think there's really a difference there in any meaningful way. And it's kind of funny, courts and hearing officers seem to treat them as one and the same. Often the decisions will only mention one or the other. And so here's a couple examples. The first one is another hearing loss in a police officer case. It says injured worker developed a hearing loss on the job due to exposure to noise. This one, it was running sirens for a sustained period of time, radio calls, firearms training, general road noise. And if you look at it, it says noise to a greater degree and to a different extent than the public in general. Doesn't say anything about other jobs, but that's the whole order. It's vacated up here and no principal lost time. That's the end of the order. So nothing in there about other jobs, just the public. Here's another one. COVID-19 claim this is a fire marshal, and this is interesting because this happened. He contracted COVID in either March or April of 2020, so right after the quarantine started. And he, for his job duties, he was out going to the convention center for a work conference. He had to shop for supplies to prepare his office for COVID-19 protocols. And then being a fire marshal, he had to respond to these calls and first responders and EMS. And he had no known contacts with COVID outside of work. So that was one where they said, again here, the injured worker's risk of exposure is greater than that of the general public. Claim is accordingly allowed. Doesn't say anything about jobs in general. So I would argue that really you're talking about the same thing there. So I told you the second half would go faster. This is the kind of the final check-in of all three of the prongs and a translation to the simplest terms. So first, must be contracted in the course of employment, time, place, and circumstances, or in simpler terms, did the injured worker contract the disease doing work duties or at least something logically related to or incidental to the work? Then the disease must be peculiar to the claimant's employment, or conditions of employment must result in a hazard greater than employment generally, which means the same thing as the employment creates a risk of disease in greater degree and in a different manner than for the public. Which means, does the type of work the injured worker performs have a significantly higher risk for contracting the disease than for people who don't perform the job, whether they're in the public, whether they're performing other jobs, whatever? Does this job give you a higher risk of contracting the disease than other people? So essentially, there's two steps here. Can the injured worker show that they likely got the disease doing their job duties or something closely related? And if so, did they get it because those duties have an especially high risk for that disease? And it's important to remember, it's not about the job title, but the situation of the employment, what they actually were exposed to. So again, the dishwasher with the tuberculosis asylum. Being a dishwasher does not have an inherent risk of tuberculosis. But if you do it in a tuberculosis ward, then yes, it does. Cashier doesn't have high risk of lung disease, but if you're a cashier in a business where harmful chemicals are all around you being used, maybe you're working in an auto shop, I don't know, with diesel fumes, something like that, then perhaps it would. And the other thing to remember is it has to be both. You have to show not only that you have this risky job that causes certain types of diseases at a higher rate, but you have to show that it actually did. So you can't just say, you know, I'm a firefighter, I got cancer, and you have to show, well, I shouldn't use that as an example because there's special rules about that. But, you know, if you are somebody who works, we'll use that cashier as an example. If you're somebody who works as a cashier and you get lung disease, you can't just say, well, you know, I work around these harmful chemicals that gives me a higher risk of getting lung disease. You have to actually prove that you didn't get it from smoking, you didn't get it from something, you know, you have to prove that it did come from your work. Okay, so what is not an occupational disease? We've talked about what does make up an occupational disease, but there are certain things that do not and are never occupational diseases. And there's a case called Ingram versus Conrad that is used a lot to talk about this idea. It says, we believe to conclude that ordinary illnesses and colds constitute occupational diseases would extend workers' compensation laws beyond their intended purpose. It is not contemplated by the lawmakers that the law should cover health insurance. So essentially what they're saying is, we'll use this later, ordinary diseases of life. So diseases that are common run-of-the-mill diseases that are just a part of life are not compensable. Whether you got it at work or not, they're just part of life. Example would be cold. Another example would be something like flu, pneumonia. And the fact that these are ordinary diseases of life, it would also just make it hard to prove that you had a special hazard or risk for it, because I'm not sure how you would prove anyway that a job would have a higher risk of getting a cold or a higher risk of getting a flu. I guess any job where you work in close proximity with others, but that's not going to work, because any disease that is as widespread and just a part of life is not going to meet the burden there. Okay, so now if we apply these rules to COVID-19, we know it has to be contracted in the course of employment, affiliated employment, conditions of employment with a greater hazard, and greater degree than the public. So how do you do the first? How do you prove that you got it at work? And probably the best you can do is just to show that it's more likely than not that you got it at work. Typically, if you can show how many people had it during that point, you can show any other contacts, you can show any kind of statements from HR or supervisors that there was an outbreak. And then it's also helpful to be able to eliminate other possible causes. So if you have can testify or sign an affidavit that your spouse or children didn't get it before you, or that you were not that you were social distancing, not going out, not that you were masking, things like that. Anything you can do to show that it was more likely than not, because it's going to be awfully hard to prove the exact moment and place that you got COVID-19. And then as far as numbers 2 and 3, the hazard and the greater risk of disease in a different manner. What kind of jobs are we going to be looking at constitute a special hazard getting COVID? Well, we've already talked about a couple. We talked about the fire marshal and the police officer. Those are jobs where it has been argued fairly frequently that they have a greater hazard than the public in general. So in 2022, last year, there was a study that showed the COVID death rate among police, fire, corrections, security, et cetera, was twice as high as the overall death rate of workers in 2020. So in the first year of the pandemic, they were twice the death risk. So the question is that changing now that work from home and quarantine is essentially over? Because part of the risk, or part of the reason that police and firefighters were arguing that they had this special risk is they were these so-called essential workers that were not able to quarantine. They were not able to work from home while this pandemic was at its peak. They were the only ones, or some of the only ones, who had to be out there interacting with the public and being in close proximity with people, not knowing who may or may not have the disease. So that was, I think, why a lot of these police and fire and EMS workers were found to have met that prong of having the greater hazard than other jobs and the public. But now that that's over, a good question is there anybody now who has not just a higher risk of COVID, but is significantly, because based on some of that language from earlier cases, a significantly higher risk or higher hazard of getting COVID? And if not, then we're probably nearing the end of COVID claims, because if we can't show that there is a higher hazard, then we can't show that it meets the definition of an occupational disease. It's not a scheduled disease, so we can't go that route. So I want to wrap up with some real life examples. The first one is the deputy. His claim is allowed for COVID-19. He was, it says his risk was greater in his employment working in a patrol unit than the risk associated with employment generally, when a great many workers work from home. So again, that's what I just mentioned. I think that was what played into a lot of these decisions, is he couldn't work from home when a lot of other people were. And he also noted they found filed evidence that no fewer than 7 deputies who worked together in the patrol unit contracted COVID-19 in a 10-day period. So approved. He's got the special hazard, or at least that's what they found, because he's out doing all this work while people are working from home. And he has the evidence that more likely than not, he got it at work, because 7 deputies within a week and a half that he worked with got it. Next one is the police officer. Police officer, the injured worker interacts with members of the general public. He's unable to socially distance. He spent several hours sitting next to his partner in his patrol car with little ventilation due to the cold weather. His partner had COVID. 6 out of 16 officers in his unit had COVID. So that's a greater risk than the general public. Well, that's interesting too. They, again, just says general public, doesn't say employment in general. And this one says employment generally, but doesn't say public. See, this one says public. So they are treated pretty much interchangeably. So again, here's one where they find a greater risk of getting COVID. Here is a patrol officer. I think it's important to note this is 2022. This is just last year, long after the quarantining. So police officer regularly interacts with the public on a daily basis, patrol car with a partner who had COVID-19. So very similar to the last one we just talked about. Frequently spent time in close proximity with coworkers, general public, including significant patrol car time with his partner. Here, an officer does not find that the claimant's job is distinguishable from many other places of employment where employees spend time in close proximity to each other in enclosed spaces while frequently interacting with the public. Additionally, the hearing officer finds this employment does not create a risk of contracting COVID-19 in greater degree in different manner from the public, as any member of the public encounters a risk of contracting COVID-19 in public settings. So my supposition here is this because the quarantine is a thing of the past? Is this because many people are no longer working from home? Many people are doing jobs like this. Now, I mean, I'm not sure how many jobs interact with the public as much as police, but there are some, and this has to be a significantly greater risk, is what we're kind of being told. So even if this is on the higher end of the risk, it doesn't seem like it's a job with anymore after the quarantining is over. It doesn't seem like it's a job with an extremely, notably higher risk of COVID than a lot of these other jobs working in the public. Next one is the sergeant. So this is an interesting one. He tested positive for COVID, late 21. Insufficient evidence that he got it in the course of and rising out of his employment, or that his employment created a greater risk than the public in general. Worked in an office setting at a crime scene. He complied with the masking policy. Not sure why that matters, because there's no element of blame in workers' comp. Not submitted any specific documentation of a known contact. Tested positive for COVID during a period of high community spread. So, this one, he didn't really have much evidence that he actually had gotten it at work, which is the first step. And he also had the problem of the high community spread, which is kind of funny because the high community spread can be used against you, because that shows that the public has a high risk, kind of like the argument that was made in that flu case in San Francisco. The public can get it fairly easily too. So do you really have a greater risk in the public? But at the same time, many police officers could also use that as an argument as to why they did have a greater hazard, because it was a high community spread, and while some people could avoid it, they could not. So that was denied. We've got the use of force training. I think this is, this is my last example. So the use of force training. Police officers demonstrating the proper use of force with a coworker and tested positive for COVID. He'd been speaking with the officer at a crime scene, spoke with the officer in his office, removed his mask when speaking with him, was demonstrating the proper use of force on the officer, which obviously would require him to be in close proximity. And then that officer did have COVID, so he got it from that officer, or at least that's the argument. So that one is proved. So I guess the question is that I would have is being in close quarters with a coworker who has COVID a special hazard of being a police officer? I don't really see that. I guess I shouldn't be surprised that some of these decisions are inconsistent, but here the risk was that he was in close contact with a coworker with COVID, which we all could be. Now maybe his close contact is more close because he's doing use of force demonstrations. I assume you're very close to each other when you're doing that. And most of us are not touching other people or being very close to their faces, breathing on them, while we're doing our jobs. But there are many jobs that do require close contact with many more than just one person. There's, most medical jobs, chiropractor, massage, physical therapy, hairdressers are in people's, face all day. even a tailor doing measurements on you, or a tattoo artist. You know, there's lots of people that have jobs that are dealing close to people's bodies all day. So I think that one's kind of a questionable one, but that's how it came out. So what does the future hold for COVID-19? Now, this is just talking about in general, but it's also a good question for workers' comp. Here, this article says it could end up similar to the flu, leading to the need for seasonal shots. So if it does end up like the flu, are we looking at an ordinary disease of life? When it becomes endemic, which it's, depending on who you talk to, either has become endemic or is on the verge of becoming endemic, is at that point no special hazard at all. Whether you're a police officer or not, whether you're EMS, nurse, whatever, you get the flu or the cold, you're not getting a claim for that. So if COVID becomes considered an ordinary disease of life, which it seems to be headed that way, then it's probably not going to be compensable much longer. And there's at least one recent court case, I think they got it wrong, but there's at least one court case that suggests that COVID claims are going that way. Hasn't gotten to the Supreme Court yet, but it's an 11th District Court of Appeals. I'll put this up here so you have the citation, Lee Yeager versus Arconic. This guy worked with a COVID positive coworker in a furnace control room for about a half hour, very small area, no masks, tested positive a week after his coworker did. And he argued that a special hazard was working in close proximity. And the court didn't even touch that. They said, well, we don't know if it's a special hazard or not, but it doesn't matter because this is a common illness to which the general public is exposed. So it's not compensable. And I think that's very strange because he tested positive on March 28th, 2020. So that was just 2 weeks after the state of emergency. If this case came out now, then maybe, but I think that's tough to argue there. But in any event, I think we're going to be facing this decision or this reasoning more often now as we get closer to what you would call endemic. So I guess my question is, how is that different than the police officer back in March of 2020? He can't work from home. He has to be in close proximity with people. One of them had COVID. Maybe the difference is that the police have more encounters, but on a daily basis, he only had the one, but I don't know. I mean, it seems like splitting hairs really. And here's that use of force training. Is that really any different than this? He had one contact with one COVID positive coworker in close proximity, which is essentially what happened with the guy in the Yeager case. So it just shows again how subjective a lot of these can be. And part of that is because diseases in general are not quite as clear cut as injuries can be. So to wrap up, I think COVID claims, like all occupational diseases, are going to depend on first showing that it was likely contracted at work, and then showing that the job had a significantly higher risk of getting that disease than other people have, whether it's the public or other jobs or whatever, just that it have a significantly higher risk. And I'm not sure there are that many jobs like that anymore for COVID. And I think it's unlikely that we're going to see many more of them filed or at least granted. But there are still quite a few making their way through the court system. So I think it's still relevant to know the rules. And of course, it's relevant to know the rules because they're the same general rules as occupational diseases. So these are going to be relevant considerations as long as there are occupational diseases and workers' comp. But I do think administratively, we're probably nearing the end because this is going to be endemic soon, and it's going to be, likely going to be another flu that we get the vaccine for every year. So I hope this information was helpful. I obviously the slides will be available, and I'm open to any questions for RNA.
Thanks, Doug.
Yeah.
So did you say you were going to provide the slides?
Yes.
Okay, then I will make sure to share those with the slides with those in attendance. I want to thank you. This was certainly very interesting. A lot to think about. Thank you for taking your time and sharing your expertise with us. I want to thank our members for attending today. And again, thanks Spectrum Reporting for providing the Zoom link and the video for today's session. And I will hope that everybody has a great rest of the day. And as always, if you have any ideas or suggestions for a topic that you would like to hear about, please let me know. I'm always looking for good ideas for speakers to invite. Have a good day, everybody.